Thank you, Senator Zaffarini.
Thank you.
We'll open public testimony on the committee substitute to House Bill 1438. We have Justin Gordon as a resource witness from the AG's office, and Guy Herman, still here, as a resource if he needs to. Do you want to testify on this, Judge Herman?
Yes, ma'am.
You can come on up.
Good morning. Good afternoon.
Good late afternoon.
I'm Guy Herman. I'm presiding statutory probate court here over the statutory probate courts here in the state of Texas, which are the 18 courts that are situated in Harris, Dallas, Tarrant, Denton, Collin, Galveston, El Paso, Hidalgo, Bexar County, and Travis County. We handle about 65% of the guardianship cases that generated in this state. I have been doing this over 30 years, and I have dedicated my life as a judge to make the administration of justice better for people that come under guardianship and probate and mental health. The reptile group, the real estate probate trust law section, which I am a member of, which I do not participate in any of their formal proceedings, works on coming up with legislation on each session to see if they can do something to make things better for persons here in the state of Texas. That information is given to all 50 sections of the bar. The judges get copies of it. We're offered an opportunity to complain, to say something to the state bar. We sometimes do, we sometimes don't, depending upon what they're offering up. It goes through the state bar. There's a long meeting, and then the state bar will not let those people come over here and with a bill like 1438 unless the state bar itself has determined it is in the best interest of the public here in the state of Texas. I believe this bill is in the public interest of citizens of this state. I wouldn't be over here testifying about that. Now, there have been a lot of complaints in the last few months about this bill, some of it based on misunderstanding of what some of this means. I'd like to talk about a few things. Bond is something that the legislature has said that a judge must impose upon a guardian. It is an insurance policy to protect a ward's assets, or the ward, him or herself, from the guardian if the guardian does something inappropriate, steals money, invests it wrongly, doesn't follow what the guidelines that you all have set up. We impose a bond. That bond costs money. This safekeeping business that's in there, if someone wants to safekeep money, you all have said to the judges, if they want to put money in a safe account where no one can get to it other than through an order of the court, judge, you can reduce their bond. And what would happen, they'd get a refund of the premium. What these lawyers have tried to do in this bill is there are limited circumstances, but there may be a circumstance when that money could be safe kept before you even post a bond. So you safe keep some money and you have a lower bond. It will save money for the individuals. That has been opposed as some sort of a barrier. Then there's other things in here. We have people that... It's shocking. There is a case in Harris County that is 9 years old, someone trying to get a guardianship, and on an allegation that this family member is financially exploiting this family member. I don't know the truth of what the allegations are, what the result is, but I know no one should wait 9 years before they can get into court. And what happens in these cases, two things. They file recusals. You all, after a number of recusals, you said that's outrageous. You all said you get 2 recusals and not a third one, where the court has to absolutely stop. So they got a new trick coming on. They will find a person from another county or within the county to intervene in these cases. There's a case I'm aware of in Harris County where someone, a lawyer out of Bexar County, came in and filed an intervention, because you can just file an intervention in the state of Texas. In federal court, you better have the judge's permission before you do it. This person filed an intervention, and guess what? Filed his 2 recusals after the other people had already used up their recusals. You talk to this lawyer, why are you over here? And the explanation is, I was asked by the lawyers in the case who had run out of recusals to please intervene so they could file more recusals. That's the basis of this motion to intervene that's in this place. You ought to, before you can come into one of these contests, you ought to file a motion with the court and let everybody have a hearing. Why are you here? I'm a family member and I have an interest in this. Fine, we'll let you in. But if I'm a lawyer who's coming over here so they can get 2 more recusals, that's not a good reason to intervene in a case. So we have that provision in there. There's a number of provisions in there that people, like management trust. Management trust didn't exist when I became a judge. But the banks came to the legislature and said, we think we can protect these assets as well as any guardian, and we can invest them and make money for these people. So you all said, okay, you're going to have management trust. We could create one out of the guardianship assets. Well, you'd have to have a guardianship, then a management trust created. Then you got rid of the guardianship. So later on, you all came back and said to the judges, let's bypass the estate guardianship of the estate and go straight to the management trust. We've done that. But when you do that, you're moving the estate money into a management trust. It still belongs to the proposed ward or the ward because they may be under guardian of the person. And one of the questions in this bill was, well, how come they're having to pay for the ad litem's? The estate would pay for the ad litem's, the guardian ad litem, attorney ad litem, attorney's fees. So the management trust would do nothing more than that. There is a bill, and part of this bill has some court costs, how they're adjusted. And there was an issue with some of the legal aid. They said, we want a statewide uniform application of how do you determine who's indigent to file a case and who's not. Those are incorporated in this bill. 4 years ago, the Supreme Court changed Rule 18A, which governs recusals. One of the regional judges contacted me, said, Judge, you all need to change your recusal statute to follow along with Rule 18 because it cuts out some of this business of people abusing the recusal process. That's in the bill from 29 on down to close to the end of the bill. There's nothing wrong with this bill. But I will tell you, I have been accused of being a criminal. I've had filings against me with the Attorney General of the United States of America by these people that are opposing this bill. I don't like it. They have sent a letter over here yesterday. I got a copy of it. They want to sue all of you because you are engaging in some sort of criminal behavior by passing a bill like this. You all seen all that stuff. These people are out of control that are opposing this bill, and it is not right. They've sued me last year. They sued Elliott Neistat last year. AG had to represent me. I had county attorney represent me. Had to hire a private lawyer. $50,000 worth of lawyer fees, time and energy, because somebody doesn't like guardianship and doesn't like the fact that the state bar or Elliott Neistat or Senator Zaffarini, whoever it is, comes up with stuff. Why should the state of Texas pay to defend me or Elliott Neistat or all of you? Because this threat I saw last night, they're going to sue everybody over here. Somebody, a lawyer over in Houston, says she's going to do that. And I can tell you some of these people that are going to testify here today have an operation where they have recommended people to hire that lawyer. That lawyer has gotten a judgment against the man that testified in front of you. He's got a $120,000 judgment for bad faith litigation. I feel bad for that man. I feel bad that they've argued that guardianship is a violation of the 5th, the 14th, and the 13th Amendment of the United States Constitution. That's preposterous. There are people that need a guardian, whether we want to recognize it or not. Most of us judges, do you think we want to have these cases where the family is fighting? This sibling says, I want to be guardian. That sibling says they want to be. No, we don't want that. But it happens, and it runs the cost up. I have brought pile after pile of pleadings that these people file. This is probably 20 pounds worth of stuff. This is filed in Dallas, Fort Worth, Harris County, some in Travis County. Some of these people run around here. I got a case transferred out of Bexar County to me. Why'd they leave Bexar County? Because they didn't want to deal with this person. Somebody here has a magazine. He's been coming around here pushing this stuff, claiming that we're human traffickers. Outrageous. Outrageous. And that's just not right for the way these people have done. They've trashed me. They've trashed the lawyers. They're trashing you all. It's just inappropriate. And I want you to pass this bill. It's a good bill. There's nothing wrong with it. And I will give all of this to you all if you want.
Okay. Well, you can pass it out. We'll make sure the members receive your information. Thank you for being here, Judge Herman. Okay, we'll call up Ayan McGinty. I'm sorry. Okay, we'll register in her. For the record, she was against the bill. She's a volunteer advocate from Self-Guardianship Reform Advocates for the Disabled and Elderly. Debbie Salinas Valdez.
She also.
Okay, she was against, and she was with the same organization. Kelly Smoot.
Here.
Come on up, Ms. Smoot. And J. Christy Hood. Ms. Hood, you can come on up. And Sherry Jo Huston. Oh, sorry, I thought that was 2 words. It's been a long day. Sorry. Y'all have a seat. And we will start with Ms. Smoot.
Good afternoon, Chairman Huffman, committee members. I'm afraid Guy Herman has his facts wrong. We have never threatened to sue anyone. We have threatened for injunctive relief should House Bill 1438 become law. And I believe I have passed to each of your members' staff covering state affairs committees and House Bill 1438 a copy of that motion that we will be filing for injunctive relief if House Bill 1438 is enacted. I understand there are some committee substitutions. I've had just the briefest of chance to look at those. The committee substitutions that I have seen do not completely clarify and do not remove the unconstitutional provisions that are in here. And what I guess the most disturbing to me, given Judge Herman's little rant that he just went on, is that he's not telling you, he's misrepresenting our position, which I take exception to, and he also is not telling you how these laws are actually used in practice by probate courts, such as his own probate court and probate attorneys that practice in front of him. 1438 would allow Judge Herman to aggrandize his judicial powers and would aggrandize powers to him that he currently does not have, and he did not mention that at all. And the other thing he mentions about management trusts, and what we have seen typically in 99% of the cases is that management trusts are used to destroy a ward's financial planning exercise that may have gone through. Because when a management trust is created, everything is liquidated and put into the management trust. And that can destroy years of careful financial planning. And so that if anyone ever gets out of guardianship, they end up with no money. And they end up with their bills not having been paid. They end up, if their house hasn't been sold, it's in foreclosure because the guardian didn't pay the money, didn't pay their mortgage. And ultimately, what he is not telling you, what Guy Herman is not telling you, is that there is no means of redress for victims that we see will be forthcoming the way victims are forthcoming under current laws. That if they get out of guardianship, there is no way for them to get back the money that the courts have seized under 1438 and existing estates code law. And that is wrong because that's improper search and seizure, that's improper, that's a lack of due process. And you are basically committing people, and even with the proposed language changes I saw, I still believe it's unconstitutional because you are seizing a person's money before a guardianship has been formally approved, and that is a failure of due process.
Thank you, Ms. Smith. Senator Zachary, did you have a question? Or no? Oh, I thought I saw you. All right, anyone else have any questions? Thank you very much for your testimony. Ms. Hood?
Thank you. I also only had the briefest moment to look at the substitute, and I'm going to go very quickly through the issues that I found. Page 5, line 4.
Okay.
You need to define, page 4, line 23. What is an interested person? Currently, an interested person could be an auto mechanic who's mad because he didn't get his bill paid. That needs to be defined. Let's see. Page 11. It says the judge has discretion. Well, please spell out that discretion. If you're going to make a law, make it clear. Page 13, lines 22 through 25. If you're going to do it, be consistent. One person may pay $200 for an ad litem. Somebody else may pay $600. And it all depends on who the judge is buddies with. Make it consistent. Do not let fair and equitable be the definition. Make the definition be maybe a percentage of the person's wealth instead of all of it. Let's see. Page 24 and 25, section 5906. I can't read my own writing, I'm sorry. Let me turn to that page real quick. I'm sorry, 1 second. Oh, here's one.
You're out of time, but since you lost your place, I'll give you, a few more.
I really appreciate it because I am trying to work with everyone here.
Sure. Go ahead and find your spot.
Okay.
And you can have another minute.
Okay, section 24, page 24, it says section 29, the finance code. There really is a problem, a due process, and also the fact that it's a misuse of that law. If you look at every other section that says it allows someone's bank account to be raided without due notice to the person, they're all investigated for criminal things or mismanagement things. It's not fair that a person who's done nothing but get old be subject to that. Thank you.
Thank you very much for your testimony, Ms. Hood. Ms. Johnston?
Yes, my name is Sherry Johnston, and I vote against the bill. I'm asking that, first of all, the gentleman, Mr. Herman, was talking about all these recusals in Harris County Court. There were my recusals and Peterson's recusal, and a young man named Andrew was under horrible guardianship. And we did all these recusals to try to get the guardian, the judge, to stop this abusive guardianship. And 2 of the victims had died since then, and the young man ended up in a guardianship with his father, abusive father, taking care of him because they didn't have an ad litem that was competent enough to do the job, nor the judge. So back to this. We are informing the committee that probate judge Guy Herman and other judges, which never give anybody in guardianship the opportunity to have a simple trial by jury or due process, is behind these bills. Guy Herman is making himself above the Texas Supreme Court, which he states that the homosexual marriage is constitutional and brings same-sex marriages into his courtroom, saying that it's a marriage. This is in probate. We have a judge here that says in probate he's above the law. This bill strips away any process in which anybody can interject, apply, complain about the guardianship without putting up the deposit, and then security for costs, which I had to do that. Also it goes in and went into hundreds of thousands of dollars. My mother had to pay $300,000. I had to pay $70,000 just to proceed in these court proceedings when she died. This bill allows for the selling of your property or bank accounts for safekeeping and making sure they get every drop of money from the state for themselves. My mother didn't get this, they did. This bill allows for foreign countries to apply for guardianships. It also makes everyone accountable for all costs except for the attorneys. We're asking you to vote no on the bill. This bill makes everybody a future victim of guardianship by professional guardianship service providers, and the present guardianship law is under the state's code, which makes the word irreparable in the state's code, and we as citizens are overwhelmed by our country collapsing from within. We're being oppressed. Every fabric of our moral, financial, civil, military, and social values are being attacked with fierce oppression, and we as citizens are overwhelmed with the violence in our neighborhoods, cities, and our borders, human trafficking in Harris County and others, ISIS, financial collapse, military oppression, JHAM 15, local and state judicial abuse. And we're just asking that the Senate not pass this bill. This is the new guardianship. Is the new name for the American slavery. Thank you.
Thank you very much for your testimony, ma'am. This panel is excused. All right, we'll call up